Welcome back, dabblers, to another Quickie with Lucy, where the briefs are short, the roasts are long, and the only thing more laughable than John's complaint is the evidence he thought would help him.
Lucy does dabble, Lucy does dabble, Lucy does dabble, Lucy does dabble, Lucy does dabble.
We've seen the complaint and the amended complaint. We've seen Danny make his entrance. Now it's time to dismantle John's papers one at a time. Today we continue to cover everyone's favorite LOLsuit, where Stuttering John Melendez is suing Karl and Shuli, and Who Are These Podcasts, and the Shuli Network over the right to publicity. Specifically today we're going to be getting into Exhibits 7 through 14, or as I like to call it, 7 reasons why I would never personally hire Tabor Benedict Esquire. The motion to dismiss package. We're starting out by talking about the defendant's motion to dismiss. Anytime that we're talking about dismissing something, it's pretty exciting, right? But I gotta admit, not a super duper flashy thing. It's no Exhibit C, which we'll get into later. But this is the time that Danny, who is the attorney for Karl and Shuli, gets to show the court that John has no case.
And if there's one thing I do love, and that's justice. And I don't believe that somebody should make fucking statements without knowing the facts.
So what's the play? Danny goes claim by claim and refutes the allegations in the complaint and the amended complaint. The complaints allege that Karl and Shuli violated civil rights laws sections 50 and 51, which are New York's publicity rights statutes. To win under these statutes, you need to have two things. One, your name and likeness need to have been used. And two, this likeness needed to have been used specifically for commercial advertising or trade purposes without consent. That's the whole ballgame. Here's the reality and what Danny discusses within his motion to dismiss. John's complaint doesn't allege either one of these properly. No commercial use. The defendants never put John's face on a billboard.
New Billboard Day!
This year, give her
Genital warts.
Whatever you say, Mr. Billboard.
They never sold beer with his voice.
Do you think you have an anger or a drinking problem? I would say both.
They never dropped him into a video game. They just talked about him. Commentary, criticism, that is protected speech. Courts in New York have said it 100 times. Being discussed on a podcast or in the news is not commercial exploitation. No damages are alleged. John's complaint demands $600,000, but never explains how he got to that number. Was it lost wages? Nope. Canceled contracts? Nope. He just writes down a big, huge number, and the law requires more than this. Duplicative causes of action. John tries to dress up the same claim in multiple ways. The defendant's motion to dismiss points out that it's all just a rehash of the same weak theory. And I'm pretty sure that judges hate that. It wastes their time. Plus, let's be honest, the couch cushions have nothing to do with this lawsuit. And John really belabors them. Newsworthiness and the First Amendment. Even if you stretched your imagination and called what Karl and Shuli did use, it falls underneath the newsworthiness exception. Effectively, this says that public figures don't get to censor commentary just because it hurt their feelings.
How about feeling bad for me?
Yay, free speech. In summation, Danny's motion says, Your Honor, even if we took every word of John's complaint as gospel, it still does not add up to a violation of the law. Now, in a normal Section 5051 case, the plaintiff would come up with a clear allegation. Like I said before, an example of your face being on a billboard, or your voice being used in a beer commercial, or their likeness being in a video game without permission. Then the defendant will argue exceptions, and the court weighs discovery. That's how these cases usually go. Here, John's complaint is so hollow, it collapses under its own weight. He's not fighting to protect publicity rights. He's fighting to protect his feelings. And that is not what this statute is for. That is exactly why the defense front-loaded everything in this motion. They knew that they could gut the whole case before it even started. This wasn't just routine, it was the legal equivalent of flipping a Monopoly board over and saying, "Game over, John."
So I prefer games that involve the brain, like Scrabble, backgammon, even trivia crack.
Another big aspect of the motion to dismiss relates to SLAPP.
Aren't they trying to do a SLAPP? I don't even know what they're doing.
This is huge. You do not invoke this part of the law unless you mean business. Here's a breakdown of how Danny uses it in order to support the defense. Anti-SLAPP analysis, CPLR 3211G, New York Civil Rights Law, Sections 70A and 76A. What is the purpose of anti-SLAPP laws? Defendants can invoke these sections, which allow a defendant to strike actions targeting public participation without substantial basis. The purpose is to prevent lawsuits which are intended to stifle constitutionally protected speech. Here, defendants Karl and Shuli argue that claims involve speech about a public figure, Melendez, StutJo, which is inherently in the public interest, according to Section 76A. In fact, the first amended complaint filed by Stuttering John itself actually admitted that he is a celebrity. In fact, it bragged about it. He's well known in broadcasting and comedy, making the speech newsworthy. Coverage included commentary, parody, ridicule, satire, and comedic events, all of which are protected forms of expression. In addition to that, we get a shifted burden of proof when SLAPP is invoked. Under anti-SLAPP law, once the defendant shows public interest involvement, the plaintiff must now demonstrate that the claims have a substantial basis in law and fact. So again, that's getting shifted back onto the plaintiff. Here, defendants Karl and Shuli, through their attorney Danny, argue that Stuttering John cannot meet this burden because, one, he admitted in a public video that he consented to recordings and distribution.
Because I've been talking to Kate Meany. I know she's taping me. We've known since the beginning. I'm trying to feed as much nonsense as possible and will continue to do it until she hands it over to Lady K or the shit layer or one of these fucking losers. But I'm letting you know for sure what the date is because I don't want these people to say, oh, John didn't know. I knew from day one.
2, that counts 1 through 3 are legally deficient. This includes things like the New York residency argument, which basically says that Stuttering John didn't have the right to file this lawsuit regardless of anything that's in it because he was not a resident of New York State. And 3, prior court rulings already rejected similar claims. In fact, here we get to talk about the Sirius XM case, which is awesome because it is another thing that Stuttering John has lost at. What about evidence of malicious or knowingly false claims? Stuttering John's video and prior admissions show he knew the recordings were consensual under the first amended complaint. Further, Stuttering John alleges that the tapes, which are the recordings between Stuttering John himself and Kate Meany, were illegal recordings. That allegation of illegal recordings is knowingly false. This strengthens defendants' request for dismissal and mandatory fees and costs under the anti-SLAPP statutes. The motion to dismiss doubles down, explaining that the speech is protected despite commercial use. Specifically, the first amended complaint acknowledges that defendants' actions were comedic, satirical, and for entertainment, although they sometimes generated revenue. New York anti-SLAPP protects such speech even if it has a commercial value, provided it involves public interest commentary, which I think that this does. So what's a summary of the anti-SLAPP defense? The defendants Karl and Shuli need to satisfy the initial burden of showing that the first amended complaint targets speech about public figures, a public figure specifically, Stuttering John. The plaintiff cannot meet the shifted burden because 1, he consented to the recordings, 2, the claims are preempted or jurisdictionally defective, and 3, the speech was protected commentary, satire, and newsworthy entertainment. As a result, the anti-SLAPP statute supports dismissal as well as the defendants being awarded fees and costs. And potentially the plaintiff or the plaintiff's attorney could also get sanctioned for knowingly false claims.
He's dropping sanctions! By which I mean anvil!
So what are our key takeaways here? This motion to dismiss is heavily anti-SLAPP centric, relying on sections 70A and 76A in order to dismiss claims targeting public speech, shift the burden to plaintiff to prove a substantial basis, which he cannot, leverage admissions in plaintiff's own video to demonstrate consent and undermine the allegations within the first amended complaint.
So when she decides to release this tapes, and I'm telling her everything, I want to bang her on top of the Eiffel Tower, anything I could think of. So there you have it.
And emphasize newsworthiness, satire, and public figure status in order to protect the defendant's speech.
Is this really newsworthy?
Yes, very upsetting.
If the anti-SLAPP stuff within the motion to dismiss is granted, it will stop the lawsuit, require payment of fees and costs back to the defendants, and may include sanctions. Amazing. I have to say that I just love the motion to dismiss so much. It is so well written and so thoughtful, but it is far from the funniest thing that we are going to be discussing today because we are about to get into Exhibit C, or filing number 13 within this LOLsuit. What is Exhibit C? This is one of the exhibits to the motion to dismiss that we just talked about. And oh, by the way, it's a video of John himself.
So, you know, I'll keep this going. Today, if I talk to her, I'm going to say that I got hired I have an interview at a TV station for $80K a year, and I got an interview with a radio station. That's the new one I'll do today.
This was filed by the defense to show exactly how Stuttering John talks about himself and others. Just think about that for a second. John spent years uploading rants, podcasts, YouTube streams, all in his own words. And the defendants didn't have to hire investigators or dig through confidential files. They just had this sitting on their plate ready to go. So what is this video? Well, John does what he always does. He contradicts himself and inflates his own resume. It's almost as if he looked at the defendants and said, "Hey guys, do you want this evidence? I have some. I'll share mine with you." He would never share, let's be honest.
I'll share the screen. Why not?
Lawyers dream of an exhibit like this. Direct statements from the plaintiff undermining his own case. This isn't just an admission against interest, it is self-sabotage on camera.
I know she's taping me. I'm trying to feed as much nonsense as possible and will continue to do it until she hands it over to Lady K or the shit layer or one of these fucking losers.
Now we got to get into filing number 14, the stipulation. This filing is a stipulation to adjourn deadlines. This is pretty standard administrative stuff where the lawyers on both sides agreed to give themselves more time in order to look over the paperwork. But ask yourself this, why did Tabor, Stuttering John's attorney, need more time? Maybe Tabor needed more time to proofread.
It was the best of times. It was the blurst of times. You stupid monkey.
Maybe Tabor needed more time to figure out how lawsuits work. He doesn't really seem to understand how.
You really believe that, don't you?
Maybe Tabor needed more time to learn how to spell his own name.
It felt like they weren't even spell checking them.
Or maybe, just maybe, Tabor needed more time because he realized that Exhibit C was a legal pipe bomb sitting on his client's lap. How does this case stack up? Now let's zoom out here for a second. What does a case like this normally look like? In a typical Section 5051 case, you'd see a plaintiff with a clear claim, a photo, a commercial, an ad campaign, something like that, using their image without consent. The motion to dismiss usually turns on fine points. Was there consent? Was it newsworthy? Was it parody? Was there a legitimate commercial purpose? Here, we have none of that. John's complaint is hollow. No clear instance of commercial use. No damages explained. Just vague accusations that Shuli and Karl exploited him by talking about him on comedy podcasts and in commentary. The comparison couldn't be sharper. A normal plaintiff is fighting to protect real publicity rights, but John is just fighting to protect his ego. So when Danny and his team file their motion, it is not just routine, it is dissection. They're not just saying, "Judge, dismiss this." They're saying, "Judge, this was never a case in the first place." So there you have it, filing 7 through 14, a motion that dismantles John's complaint, an exhibit where John dismantles himself, and a stipulation where Tabor quietly admits that he needs more time in order to be able to keep up. In a normal case, Exhibit C might be a smoking gun, but here it's more like a clown horn, honking every time John opens his mouth.
What are you, fucking nuts? Why are you whining? Who the hell are you? I'm your better half.
Next time on A Quickie with Lucy, we'll be talking more about venue changes and possibly the opposition to the motion to dismiss. Will it work? Or will it be messy, embarrassing, and doomed to fail? Until then, keep it quick, keep it dirty, and remember, the only thing John's filings prove is that sometimes the best witness against you is you.
All these armchair attorneys, so funny, so sad. See, Lucy, you are so fucking stupid